One of Chairman Wontumi lawyers, a year lawyer, and the appear could be Eddie Simbi Abatuja. I just say, or no, I just say, handy a fence saying, Chairman Wontumi case, I just say, or handy over to a year lawyer attaching Eddie Astemno, Emanukusine Via. Now, a year lawyer and the appear Eddie Simbi Abatuja say, a year before Crasso over handle over the case to a year lawyer Atachiano, a year Chairman Wontumi Eddie Canning Tinkomo say, although say or handy or the case name lawyer Atachian Parks or Rankas would say, a year denya be convicting such as say, be finding guilty of the why inti. And na lawyer friends a lawyer and the appear could be air case only Chairman Wontumi Eddie Komobi na no one come na a year lawyer and the appeal could be ababonti abe confess Eddie go entian se obrenom yenje brani kwati in semwa a year and the appeal could be what the Eddie ato a year Ghana many name a year Wontumi charge the and the bonum ni now so of any guilty I was our charges na Eddie born yenje bre.
You see, the day he was imprisoned, I spoke to you, and you said on the morning of the day he went to prison, he called you, and he said you should do what?
Indeed, I told you, and I still stand by that, and that is the fact also. He told me that he had prior information that he will be convicted, and therefore gave me instructions first after the conviction.
I see.
And this is a fact.
He had prior information that he was going to be convicted on Monday.
And again, I am going to show you why probably he had that prior information. This is a copy of the judgment. Look at it. Judgment didn't go to even the registry of the court. So there is nothing to show that there is. This is on a regular A4 sheet. The courts have their own sheets that they use in publishing judgments. So there is no indication of the stamp of the registry. You go down there at the end of it, and it says that counsel, and in this particular case, defense, attaching for the first and third accused persons. Attaching was not in court on the day. So it would have been that Mr. Appiah could be holding the brief of Samuel Attaching.
But you were not in court on that day.
No, I'm saying
you're just taking an example.
Somebody else,
even before we
somebody else held the brief on the day.
Right.
So ordinarily,
the person's
name will come, and then you refer to the lead counsel or the senior whose brief the person was holding. Now, so this is a publication that came even before the judgment.
Did you ask that Chairman Wontumi further on Monday why he suspected that he was going to be convicted on that day, even before he went to court in the morning?
And I'm saying that he probably had a copy of this before the judgment.
He had a copy of the judgment
before it was delivered. And I'm justifying that with these observations. But the most important thing I want to say today is that people who have not had the opportunity of reading the proceedings, people who have not had the opportunity of even reading the address and going about relying on only the judgment and making some pronouncements.
We'll get into
These
that.
people don't have the necessary experience.
Some of them are actually blaming you for not doing a good job.
Let me finish.
Yes.
These are observations of the judge, not observations of the total proceedings. And in any case, the matters that were cross-examined on that form part of the records may not have been picked by the judge. It doesn't mean we didn't cross-examine on those.
Okay, we'll get to that. I think you're referencing page 28 and 29 of this ruling.
Yes.
Well, I'll get into that. that. But why would Chairman Wontumi call you on the morning that, look, if I'm jailed, start appeal processes? You were not his lawyer at the time.
Yes, but appeal is a different process altogether. When the judgment is given, a client has the opportunity to change for the purpose of the appeal. So it doesn't follow that we will do the case up to judgment and you continue as of right to be the lawyer for the appeal. No, he can change at any point in time. Probably at that time, he thought that if it happened that way, he would prefer that I probably be part. And indeed, from my discussions with him yesterday, he still wants me to be part of the appeal because
after you have washed your hands off the case.
Oh yeah, but you can always come back.
What did you see?
Because the appeal is a different process altogether
right.
from the instant case.
What did you see? Reason why you took the decision that in the dying days of the case, you say, I don't want to have anything to do with you.
I gave my reasons at the time that because of the environment that we have created as prosecution and defense and even the court, it was not conducive for us to pursue justice under the circumstances. So sometimes personality crashes and things like that may bring situation in the courtroom even not conducive enough for us to be able to collectively seek justice. And indeed, don't forget that the object of the judge or the court itself is to seek justice. But if personality clashes are preventing all of us working together to seek justice, then it means that we need to recreate an environment that will give us that opportunity. And I thought that at that time, opting out to bring in a new person who would continue. And let me also put it on record, any new person coming had every opportunity, if you found the evidence inadequate, to recall witnesses. Indeed, he had even opportunity to recall even prosecution witnesses, defense witnesses, and even call new or fresh witnesses. So the inadequacy of the evidence cannot fly because if you had opportunity to do that, the presumption is that you found the prevailing evidence as adequate, which you rely on
to
do your address.
They didn't do that.
Of course.
Okay.
Yes.
So they came in at the time where the expectation was that they must, the case was determined to a certain point, and dates for judgment was fixed. So they were boxing.
That is not the case.
Because they pleaded to do a few things and they were not granted the
opportunity to do it. Anytime you come in and you are recognized, and don't forget, when the new lawyer came in, time was given to him to even observe.
Judgment date had already been given.
Yes, but it was changed.
It was changed from
yes,
because even application. I'm coming. Even application for interpretation was quashed, and because
that is another matter.
Yeah, I'm just saying that there was no leg room for them.
There was a room.
But let's get to the
given to him because at the point that he came in and announced himself in the case.
Okay.
The matters were all before him. And he said that I need to even study the brief, which was his legitimate right.
Yeah.
And it was all given. And having studied the brief, then you will come in with your prayers. I need to recall Mr. A or Mr. B or even call a fresh witness. At that point, if the application had gone that I need to recall Mr. A, it was something that the court would have determined and allowed for Mr. A to be recalled. And don't forget that Article 19(1) requires that he be